Our second topic for today is legal issues for the entrepreneur. As an entrepreneur, we need to be aware of certain issues that have legal implications as we go about our businesses. We want to be looking at one, intellectual property. And under intellectual property, we're talking about patents, trademarks, copyrights, and trade secrets. The second one is licensing, and the third one is contracts. Let us start with those items under intellectual property. Intellectual property is any innovation, either commercial or artistic, or any unique name, symbol, logo, or design that is an asset for the entrepreneur. Such items must be protected from unauthorized use, and we can do this in four different ways. We can be talking about patents on innovations. We can be talking about trademarks on branding devices. We also talk about copyrights on music, on videos, on patterns, forms of expression. And lastly, we talk about trade secrets for methods, formula with economic value. And let's start with patents. The patent contract between government and inventor in exchange for disclosure of inventions grants. Grant the inventor exclusivity to make, use, and sell the invention for specified amount of time. The originator of any invention, before it can be used by other people, such has to be patented, and the exclusive right to use and sell the invention for a specific amount solely rests with the inventor, except that invention is exchanged in an agreement for a certain amount of money over time. The second one is trademarks. Trademarks protect words, names, symbols, sounds, or colors that distinguish goods and services. Trademarks, unlike patents, can be renewed forever if they are being used in business. Let's take, for example, the logo of a farm is a trademark of that farm, and that can only be used by that farm alone, except it is authorized by another person. The name of the farm cannot be duplicated by another farmer, and that is why in registering trade names, there is always an advertorial for people to come and dispute the name as existing before. It can also be a symbol, sound, maybe a particular soundtrack that is used in advertisement of a particular business enterprise cannot be used by other business except by authorization. This is what is called a trademark. Number three, we talk about copyright. Copyright protect works of authorship such as writings, music, and works of art that have been tangibly expressed. For example, a livestock farmer can pen down his experience over time, and a copyright of what is penned down in form of a book or writing is solely to the author and cannot be used by express permission of that author. Copyright stops others from printing, copying, or publishing without authorization. Copyright does not protect idea. Others can use idea or concept in a different manner. So if somebody expresses an idea in a public gathering, somebody else can use that idea and use it to better his lot. Under that situation, it is not a copyright and is not protected. Terms of copyright is the life of an author plus 50 years and 75 years for an institute or an institution. In other words, the term for a copyright is the life of the author. For as long as the author is alive, the copyright subsists. And 50 years after he exits the world, the copyright will still subsist. Trade secret. Trade secrets are information that businesses keep secret from public or competitors to give them an advantage over their competitors. For example, in a livestock farm, you may have a particular formula for compounding a feed that gives you an edge in form of egg production or in form of the time that a broiler will attain a specified age, which you are only keeping to yourself to gain competitive advantage over other competitors. But we can also use the Coke formula as the most famous trade secret. Nobody knows what is used in making Coke. So a livestock farmer can also have a trade secret in form of how he compounds his feed, composition of his feed, how the methodology of raising his animals that made him to achieve greater output compared to others. This can only be kept secret only to himself for him to achieve competitive or comparative advantage. The other aspect, apart from intellectual property, is licensing. Licensing is an arrangement between two parties, i.e., a proprietary right owner and patentee or patentee and the licensee. In other words, if I have an invention, I can allow somebody to use my invention under licensing. And so such person pay a licensing fee and can only use my invention for the period of license. And licenses can be renewed over a period of time as agreed by the parties. So the patent owner may give permission to or license other parties to use the invention on mutually agreed terms. The licensee will pay royalty or fees against the right to use the intellectual property. And that is why if I have a feed mill and I have a special formula or special composition that gives my feed an advantage over other competitors, if I do not have money to expand the business, I can license another feed miller to use my composition but will always be acknowledging my name as the inventor. And it just say this feed is produced under license of whatever name I'm giving to my name. So licensing is done to either expand the business or to start a new venture. If there is an existing patent that might involve infringement, licensing may be considered. The last one is what we call contract. A contract is a legally binding agreement between two parties, e.g., an entrepreneur's contract with vendors, with landlords, of the client. For example, I may have a business in which the land that I'm using for my livestock production is a rented land. And for me to successfully use that land, there must be an agreement between the landlord and me that is using the land. And such is called a contract. It is important to know that a contract must be written, and that is preferred over a verbal one because written contracts are termed as valid and legally enforceable in case there is legal engagement or there is a legal court proceeding arising from the contract. Verbal, verbal contracts may not be tenable because it can be disputed. Entrepreneurs must take care of the following essentials when they are writing a contract involving their businesses. One, all involved parties shall be named along with their rules. Olushiji Chowande is the buyer, while the seller is Arogunadishi. So, the buyer and seller or licensee or licensor, their names must be written with their rules. Now, secondly, detailed transaction, exact location, if it's a land, exact location of the land, the um, the east boundary, the west boundary, the south boundary, the north boundary, and the coordinates must be detailed in that transaction. The date and time of purchase and the place of delivery must be indicated. Number three, exact value of transaction. If the land is purchased at a sum of 1.5 million naira, it must be so indicated in that contract. And lastly, involved persons' signatures must be obtained in the deed. The signature is the seal and is the sign that the contract is agreeable to both parties. And there must be witnesses to their signature to be sure that those who signed the contract are actually those parties that are involved. Now let us recap. Legal issues that we want to talk about or that we have talked about in case we are establishing a business include what we call intellectual property. And that intellectual property, we can talk about patents, and talk about copyright, and talk about trademarks, and talk about trade secrets. The other components are licensing and contracts.